A lot of Filipinos dream of building a house, but here, as a question that is more common than you think. Can you build a house on land that is not under your name? Some people build on land owned by parents, relatives, or partners, thinking that as long as there's verbal permission, it's okay. But in the eyes of the law, that can be a recipe for future disaster. Today on Kalye Talk, let us break down what the law says about building on land you don't own. The difference between permission versus legal authority. What happens when the landowner dies, sells, or revokes permission? How this affects your building permit and taxes? And real stories of houses built on borrowed land and what went wrong. If you're planning to build on family land, you need to listen to this before you lay a single hollow block. The truth is, you can build, but with legal guardrails. Without it, you're investing in uncertainty. One of our community members asked us, "My husband and I are planning to build a house on my parents' property. My dad said it's okay as long as we get his permission. Do we need anything else? Your dad's permission is a great start, but that alone may not be enough." Why? Let's look at the law. Under the Civil Code of the Philippines, one can build on another person's land with the latter's consent. However, this consent must be express or in writing. Verbal permission is not enough. This means that if your father allows you to build on his land through a verbal agreement only, then you're building at your own risk. If ever your father sells the property to someone else or revokes permission for you to build on the land, you will have no legal recourse but to demolish the house you built. So how can you protect yourself from this happening? You can ask your father to execute a deed of donation in your favor or in your name and that of your husband as konos. That way, the property will be transferred to you and your husband. Then, you can apply for a building permit. What if your parents refuse to transfer ownership of the property to you? They may be hesitant to do so because they still plan to use the property. In that case, you can ask them to execute a quitclaim in your favor. A quitclaim deed is an instrument in writing whereby one person conveys his right to a specific property to another, renouncing and releasing any and all interest therein. By getting a quitclaim, even if the title remains in their name, you now have some form of legal authority over the property. Then you can apply for a building permit in your name. But why is this important? Because the building permit will be under your name, the owner of the improvements. And if your parents sell the property to someone else, then the new owner will also have to deal with you, the owner of the house, to demolish it or to buy it from you. Also, if you fail to secure a building permit in your name, then the improvements you make on the land will not be reflected in your tax declaration. As a result, you'll have to pay real property taxes on the land only. And even if you do secure a building permit, failure to register the same with the local assessor's office will result in a lower tax assessment for the property. Instead of having it based on the actual value of the land plus improvements, the tax assessment will be based only on the land area. We had a viewer who sent us this message. She says, "Our house was constructed on my husband's grandfather's land. He allowed us to build our house on a portion of his property, but he never had the property in his name. It turned out that the property is still in the name of my husband's grandmother, who passed away many years ago. Unfortunately, we were not able to ask for a written permission to build on the property. So does this mean that we have to demolish our house?" Based on the story, it seems like the house was built on borrowed land without written permission from the owner. Also, the property is not yet registered in the name of the grandfather, so there's no record of ownership. Moreover, the grandmother who should have been the one to give consent has already passed away. In this case, there's really no other remedy but to demolish the house, unless, of course, they can prove that the grandfather had legal authority to dispose of the property, even if it was still in the name of his mother. Feel free to send us a message. We might feature your story in our next videos. Remember, you can build on borrowed land, but with legal guardrails. Without it, you're investing in uncertainty. Thanks for watching. Subscribe to our channel for more informative real estate videos. You can also check out our videos on house and lot property investment for beginners. See you next time.